Welcome to Episode 4 of the Legal Foundation module, Protecting Your IP, Trademarks, Copyrights, and Trade Secrets. This program is brought to you by the Series of Thoughts team. This episode is part of the Legal Foundation module, which is Module 2 of the Starting Your Company course. This course has 6 modules and 28 total episodes. Today, we are focusing on Episode 4, which is about protecting your intellectual property, including trademarks, copyrights, and trade secrets. Your intellectual property, or IP, may be your most valuable asset. Unfortunately, 87% of early-stage founders take no formal steps to protect their IP in year one. IP disputes can cost over $1 million on average. There are 3 core protections for your business: trademarks, copyrights, and trade secrets. In this episode, we will cover real-world IP disputes, the 3 protection types explained in plain language, a USPTO trademark search walkthrough, and your action checklist for tailored next steps. We'll begin with some real-world examples showing when IP mistakes become business-ending problems. Understanding these missteps is the fastest way to protect yourself. In one case, a SaaS startup spent 2 years building their brand under an already trademarked name. The cost of rebranding, including lost marketing spend, was over $200,000, plus months of distraction. A simple 20-minute trademark search could have prevented this expensive conflict. Another case study involves a logo designed by a freelancer for $150. 2 years later, the founder realized the freelancer owned the logo because there was no written IP assignment agreement. The lesson: creative work produced by a contractor belongs to them by default unless you have a written IP assignment agreement. Always get it in writing. Trademarks, copyrights, and trade secrets are the 3 core protections. Each covers a different dimension of your business. Trademarks protect brand identity, copyrights protect creative works, and trade secrets protect proprietary knowledge confirmed via contracts like NDAs. A trademark is any word, phrase, symbol, design, or combination that identifies the source of goods or services. It is essentially your brand's legal identity. Trademarks protect business and product names, logos and visual marks, slogans and taglines, and trade dress, which is the unique visual appearance of a product or packaging. Trademarks fall on a spectrum of strength. Generic marks offer no protection, while fanciful or invented words provide the strongest possible protection. Descriptive, suggestive, and arbitrary marks fall in between. The most important rule is to search before you commit to a name. Search the USPTO test database to ensure no one else holds a similar mark. A confusingly similar mark can and will be rejected. Be sure to search for exact matches, similar names, visual similarities, state-level registrations, and common law usage. The USPTO test database is free and public at tmsearch.uspto.gov. A thorough search includes checking for misspellings, phonetic equivalents, and shortened versions. The diagram shows the 4-step search process: open tests, search name, review matches, and proceed or consult. When filing your trademark, you can either file it yourself through the T system for $250 per class, which is suitable for straightforward marks, or hire an IP attorney. Hiring an attorney is recommended if your name is in a crowded space, you operate in multiple industries, or are raising outside capital. Attorney fees typically range from $500 to $1,500 total. The trademark registration timeline typically takes 8 to 14 months from filing to registration. This process involves filing the application, an initial review by a USPTO examiner, publication for a 30-day opposition period, registration, and renewal every 10 years to maintain protection. Copyright protects original works of authorship the moment you create something original and fix it in a tangible form. Protection is automatic, but registration matters enormously if you ever need to enforce your rights in court. Copyright protects written content, software code, website design, photography, music, architectural drawings, and pitch decks. It does not protect ideas, facts, names, or purely functional items. Automatic unregistered copyright allows you to use the copyright symbol and send takedown notices. However, you cannot sue for statutory damages or attorney's fees in federal court. Registered copyright, which costs $45 to $65 and takes about 3 months, enables federal lawsuits and allows you to seek up to $150,000 per work in statutory damages. Copyright duration varies. For individual creators, it's the life of the author plus 70 years. For work made for hire, it lasts 95 years from publication or 120 years from creation, whichever is shorter. For startups, ensure you own what you paid to create, as the work made for hire doctrine applies to employees but not automatically to contractors. One of the most common and expensive mistakes is the contractor IP problem. A freelancer or independent contractor owns the copyright to work they create unless there is a written agreement transferring ownership to you. Every contract with a creative contractor must include an IP assignment clause, work made for hire language, a moral rights waiver, and confidentiality provisions. These are non-negotiable for protecting your business. A trade secret is any business information that derives value from being kept secret, and that the owner takes reasonable steps to protect. There is no registration process. Protection only lasts as long as the secret is kept secret. Trade secrets can include formulas, recipes, proprietary algorithms, source code, customer and vendor lists, pricing structures, and unreleased business strategies. Trade secret protection requires taking reasonable steps to maintain secrecy. This includes using NDAs, implementing strict access controls, including confidentiality clauses in employee agreements, and establishing offboarding procedures. A one-way NDA is used when only you are disclosing confidential information, such as with a contractor or early hire. A two-way NDA is for mutual sharing, like during partnership discussions. Remember, most investors refuse to sign NDAs. Every employee should sign an Employee Proprietary Information and Inventions Assignment Agreement, or PIIA, before their first day. This is the foundation of your IP ownership. A PIIA should cover the assignment of inventions to the company, a prior inventions disclosure to exclude pre-existing work, confidentiality obligations, and non-solicitation clauses. Now let's look at the most expensive IP mistakes that founders commonly make. These mistakes are predictable and preventable. Mistake number 1 is using a name someone else has trademarked. This often results in a costly rebrand. The fix is simple. Always run a test search for exact and similar matches before committing to any name. Mistake number 2 is not owning your own logo. Freelancers own the copyright by default. The fix is to include an IP assignment clause in every design contract, ensuring your company legally owns the logo. Mistake number 3, skipping contractor IP assignment clauses. This extends beyond logos to all contractor-created assets, including code and design files. Without written assignment, the contractor owns the work, which can derail funding or acquisition deals. Mistake number 4 is treating work made for hire as a blanket fix. For independent contractors, this doctrine only applies to specific works. The right approach is to use both work made for hire language and an IP assignment clause as a backup to secure ownership. Mistake number 5, sharing trade secrets without NDAs. Once trade secrets are disclosed, they are lost forever. Be cautious in investor meetings. Always use an NDA with partners and vendors, and never share sensitive information with new hires before they sign an agreement. Mistake number 6 is waiting too long to file. IP protection is first come, first served. File a trademark intent to use early to reserve your priority date. Register copyright for key assets within 90 days of creation to qualify for statutory damages. Let's walk through a USPTO trademark search. This 20-minute process can save years of legal trouble. We'll cover going to TM search, selecting basic word mark, entering your mark, reviewing results, and checking the goods and classes. When reviewing a trademark record, you must look for 4 things. First, check the status. Only live marks pose a risk. Second, check the international class to see if the goods or services conflict with yours. Third, read the goods and services description carefully for broad definitions. Fourth, check the owner and filing date to determine their priority relative to yours in case of a dispute. When should you hire an IP attorney? DIY filing is fine if your search is clear and your name is strong. However, hire an attorney if similar marks exist, you receive a cease and desist, or you plan to raise institutional capital. Attorney costs vary. DIY filing is $250 per class. Flat fee attorneys cost around $750 to $1,500. Clearance searches cost $500 to $2,000, and office action responses are $300 to $800. Here is your IP action checklist. IP protection is a set of habits built into your operations. We'll detail what to do this week, what to do within 90 days, and what to monitor ongoing. This week, run a USPTO trademark search, audit your existing contractor agreements for IP assignment language, identify your trade secrets, and ensure all new contracts include IP assignment clauses. Within 90 days, file your trademark applications. Register key copyrights for your website and core software. Update all employee agreements with a PIIA and implement access controls for sensitive information. Your IP priorities vary by business type. For SaaS, the top priority is copyright on code and trademark on the name. For consumer products, it is the trademark and trade dress. IP protection is a competitive advantage. Clean IP makes your company easier to fund, harder to copy, and more valuable to acquire. Protect your IP today to build a defensible moat around your business.